This video is hopefully going to be a primer for you on reading court opinions and understanding what you're looking for when you read them and understanding the basic layout, the basic framework that courts use to write their opinions. Okay, so I want to remind you, hopefully we've talked about this in class. 100% of the court opinions we are going to read this year are appellate court opinions. The majority of court opinions that attorneys rely on to understand what the law is are appellate court opinions, right? So remember, we have the trial court. They actually have, and we talked about this in class, they actually have witnesses live. They can hear what they say and how they say it in tones of voice and facial expressions. They will see all of the evidence firsthand. When there's a decision in the trial court that one party or both parties don't like, they can appeal to one of our appellate courts and say, hey, I think you should look at this issue of law and I think you're wrong. But the appellate court is going to look only at a paper copy of the record. So they're going to read, they can read potentially exactly what happened in the trial court, who said what, when, but that's all of the evidence that the appellate court has to look at. And then they decide issues of law. The appellate court does not decide issues of fact. They decide only issues of law. So let's get started here looking at the Lee Lewis case. The first thing I want to show you is right up here at the top of the Lee Lewis case is the citation for the case, which includes really three things. It includes first the title of the case, Lee Lewis versus Harrison, and those are going to be the names of some of the parties to the case, but not all of the parties. And as we have or will discuss in class, it is not necessarily going to be listed plaintiff versus defendant because some appellate courts will list the party who appealed the case first, and that's not always the plaintiff. Sometimes the defendant is the party that appealed, and so their name gets listed first, and that in fact is the case in this with this particular case, that the plaintiff were the Harrison survivors. PI is a law school definition for plaintiff, or excuse me, a law school shorthand. And Lee Lewis is, one of the defendants in this case. The next part is really the specific citation, which is where you can find this case if you wanted to go find it in the official reporter books. Okay, so this is pretty old school, and I doubt if anyone really goes to look for cases in the books anymore. I think everyone is finding these cases online now, but just, so this tells us which volume of which reporter and what is the first page in that volume that you can find this opinion. So if you wanted to go to the books to find into a law library or a library with law books to find this court opinion, you would find it on you go to volume 70 of the Southwest Reporters, the third edition of them. So volume 70 of the third edition of the Southwest Reporters, and you would turn to page 778 and you would find this court opinion, and it's from 2001. That's when this court opinion was issued. Some other information that you can find on here is you can look at this and say the Supreme Court of Texas is the court that issued this opinion. And they made their decision on December 20th of 2001. That's when they issued their opinion, right? It was argued to the court. The attorneys showed up and made their arguments on April 5th of 2000, but the court decided it. They handed down this opinion in 2001. The first thing you're going to find when you look at this will be, hey, look, surprisingly enough, a synopsis. So this is going to give a really brief overview of everything that we're going to find in the subsequent few pages of this court opinion right up here at the front. Okay, and then this tells us a little bit about the opinions that we're going to find here. So for this case, Chief Justice Phillips filed a concurring opinion. Justice Hecht filed a concurring opinion in which Justice Owen joined, and Justice Jefferson also filed a concurring opinion. But Justice Hankinson delivered the opinion of the court. So the majority of what you're reading here, because really in this annotated version, all I've included is the majority opinion, is that's the law. Only the majority opinion is the law, and it was authored by Justice Hankinson, or maybe his clerk. Okay, so none of this that we've looked at so far, none of any of this is really the court's opinion. It's kind of some background information, some relevant information, right? What court is it? Who are the parties that we're talking about? When did they issue it? But this synopsis is not the court opinion. That's something that Westlaw adds. These have told us a little bit about what we'll find, but this is where the court's opinion actually starts. It starts with procedural history, which is what's happened in the lawsuit itself. And then usually, and in this case that's true, the next thing we find are facts, and I'm going to highlight the F here. We've got the facts. What is the underlying story of the case, right? What happened before anyone envisioned there was going to be a lawsuit? What happened? And then what was the event specifically that precipitated that there was a lawsuit? And these are the questions I'm going to ask you in class tomorrow. Some of these questions are going to be on the quiz. These are the things you need to understand, but that's what the facts are. What is the background story of what happened before anyone ever said, let's file a lawsuit? That's what the facts are. One of the next things you're going to find in most well-written opinions, not all opinions are well-written, but I tried to choose well-written ones for class, will be the issue. That's what is the question or questions that this court is trying to decide. One of the parties has said, I don't like the outcome at the trial court. Appellate court, you need to look at it and tell them they did something wrong. This is the thing I think they did wrong. So what is the question that they're asking? And sometimes there's more than one question. Though often for the opinions that I've edited and provided to you for class, I've tried to create really only one issue. Some of them have a couple of issues, right? What is the issue? Okay. Then what are the rules? Rules are the law. But what are the rules that will apply to this case? What is the law that applies to this case? How do we understand all of those rules, right? The court has to take the rules and then apply those rules to the facts. That's called analysis. And that is that's the largest part of the court's opinion. That's the most important part for you to understand. And that's how the court gets to the conclusion. They take the rules, they apply the rules or the law to the facts, and they analyze what happened in that case. Now, what I've done with my annotations here is when we start to repeat facts in the analysis, I've changed it to red because now it's not just the facts, it's not just the underlying story, it is the evidence that the court is relying on to support their analysis and ultimately their conclusions, right? So here in this case, but sometimes they'll state the issue and then they'll break it down to smaller pieces. So those are always this yellowy orange color. The laws I'm trying to highlight consistently in green so you can see that. I've highlighted some things in here within the analysis. So then we have a second issue in the Lee Lewis case and some more analysis for you to look at. And then ultimately the court has their conclusion. Now, this case I've cut off. There are more pages because there were multiple, remember we said there were multiple concurring opinions. A concurring opinion is when a justice on the Supreme Court says, I agree with what the majority has voted for. I agree with the outcome, but I want to tell you there are other reasons that I think are important and I want to lay out here, right? And a dissenting opinion is a justice who has not voted for the majority opinion. They don't agree with the outcome. And not only do they not agree with it, they want to write out why they do not agree with it, right? So you hear that especially a lot in reference to United States Supreme Court cases that you might hear spoken about on the news or in podcasts or whatever it is. It was a 5-4 decision. That means five justices voted for it. That's the majority opinion, and that is the law. 4 justices didn't agree with that outcome, and they had a different rationale, a different outcome they wanted, and they might write that out. Now, a dissenting opinion and concurring opinions are not the law. They're what we call dicta, but they can be persuasive. If I can tell you, well, this is the reason I think the outcome should be this way, different than this other case, right? That's fine. Professor Daignault thinks that, and maybe you buy that. It can have more persuasive value if I say, look, Justice, Sotomayor agrees with me, right? A Supreme Court justice also follows my logic and thinks this should be the law. So that's why they'll sometimes write those. So there's the majority opinion, that's the law. There's dissenting opinion. I don't agree with the majority. I think you should do something different. And then somewhere in the middle of that, also not the law, are concurring opinions that say, I agree with the outcome from the majority opinion, but I have some other considerations, or maybe I had a different way of thinking about it, and I want to write that down and lay it out for everyone. So I've actually already told you a little bit about the FIRAC process, and that is, a FIRAC is a kind of legal memo that attorneys write a lot of the time, and it's a good way to organize your writing and think through it. And so it is, FIRAC stands for F, facts, I, issue, R, rule, A, analysis, C, conclusion. So it is, not on pen, FIRAC. And that is the way, ultimately, most appellate court opinions are also laid out. And so you'll look at this annotated opinion, and you'll see I kind of point some things out to help you see when we're transferring from facts to issue. What are some words that might indicate an issue? What are some words that might indicate a conclusion? What are we looking for in the analysis? So hopefully my annotation has helped you with that, and we're going to keep working on that throughout the semester. Hopefully that's helped give you an idea of what to look for when you go to read a court opinion. Yes, this will be a little bit tricky. Yes, there will be legal words and phrases in here you might not understand. I hope that you will, open a new tab in your browser if you're reading it on a browser, right? If you're reading this online, and you will go ahead and look those words up and try to understand them. You cannot understand a sentence if there is a word in it that you truly do not understand. So take the time to do those things. It will behoove you as you go down the line. And our final writing assignment this semester, the biggest one that you have to do, right? You aren't directly writing a FIRAC memo, but you are going to need to use those skills to answer the questions, to analyze them for us. You are going to need to use your FIRAC skills, and so we're going to work on them all semester as you read court opinions. So I hope this video has helped you understand how to look at court opinions, how to read them, and gotten you prepared to get started this semester. I know it's going to be a little tricky. It might feel, for some of you, easy peasy. You're like, I got it. And for some of you, this might feel overwhelming. Hey, I was in that camp when I started law school, and that was the first time I ever read court opinions. I never read them as an undergrad. It felt a little overwhelming and it felt a little daunting, but like all other skills, if you give it time, if you put a little bit more effort in up front and you go slowly with it, you will get better at this. And by the end of the semester, you'll be pretty comfortable with it. All right, if you have other questions, ask me in class, send me an email, come by office hours. I'm happy to work with you. Good luck. I believe in you.